Good morning, everyone. My name is Chetan Singh. I welcome you in today's session on Arbitration and Conciliation Act, Jurisprudence of Enforcement of Domestic Awards. This session is organized by Chandigarh Judicial Academy in collaboration with SCC Online. And this session would be conducted by Mr. Ranjana Aggarwal, ma'am, who is an ADJ and a faculty member at Chandigarh Judicial Academy. Like any other session, this session would have, is divided into two parts. That is, one is the detailing would be done, and then after the detailing, the question answer round would be open for everyone. Without any further ado, I would request Ranjana ma'am to take the forum and start the session. Ma'am.
Good morning, everyone. Today's topic of discussion is issues relating to enforcement of domestic awards. Chetan, please put on the PPT.
Yes,
Hello?
Yes, ma'am.
The PPT is there? Okay. Arbitration is a good alternative to resolve disputes as it is fast, cost-effective, and flexible. But in the past, arbitration in India was often criticized for being slow, expensive, and ineffective. In an attempt to correct the situation, the Amendment Act was introduced. In the recent past, there have been two amendments, that is one in 2015 and another one in 2019. With these amendments and a slew of decisions, arbitration has witnessed its most dramatic changes since its enactment. The Indian judiciary is constantly recognizing the need for minimal judicial interference in the arbitral process. But at the same time, it cannot be denied that the courts play an important role at different phases of arbitral process. Their role is most prominent once the arbitral award has been rendered and is sought to be enforced. Before coming to the provisions for the enforcement of the award, it is important to refer to the object of the Act. The object is that there should be minimum judicial intervention, a speedy determination of the matter, and quick recovery of the amounts contained in arbitral awards so that trade and commerce is not affected on account of long litigation. It is also important to remember certain features. The new act has minimized the intervention of the court with the aim of resolving the dispute expeditiously. It provides that the award is final and binding on the parties. The award is enforceable as if it were a decree if it is not set aside on challenge under Section 34. And the provisions of Civil Procedure Code would apply only to the extent specifically made applicable. In Konkan Railway Corporation versus Mehul Construction, way back in 2000, Honorable Supreme Court said that the main aim of the legislation is to minimize the supervisory role of courts in arbitral process. And Section 5 is there, which specifically says that notwithstanding anything contained in any other law for the time being in force in matters governed by this part, no judicial authority shall intervene except where so provided in this part. The legislative intent was to curtail judicial interference of the civil courts. Excuse me 1 minute. आवाज एको हो रही है.
Everything all right?
Yeah, it was echoing the voice, you know.
Okay.
It was very tough for me to continue like that.
Is it better?
Yeah, now it's better.
Okay.
The object of providing Section 5 was that the legislature wanted to curtail judicial interference of the civil courts. Now, before we proceed further, it would be relevant to highlight the principles of the Act. Minimum intervention of the courts is one of the basic principles of the Act. In order to appreciate the scheme of the Act, it is very important to remember some of the fundamental principles enshrined in the Arbitration and Conciliation Act. The primary amongst them is party autonomy. If you go through the Act, every single section uses the term party. That is, the parties have to decide everything. Now, this concept of party autonomy simply requires the court to enforce privately negotiated agreements to arbitrate. We have to remember that the parties have chosen to arbitrate and not to litigate. Therefore, we are supposed to intervene only to the extent provided in the statute. Now, the question is, what are the matters in which we can intervene? There are very few matters where the legislation has provided for the intervention of the court. One is Section 8, where a court can refer the parties to arbitration. And then Section 9 is there, where the court can pass interim orders. Section 11 is about appointment of arbitrators. Court can appoint the arbitrator. If the parties fail to appoint the arbitrator, then Section 14 is there, which talks about the termination of mandate of the arbitrator. Section 27, court assistance in taking evidence. Then under Section 29A, it talks about extension of time for arbitral award. If the arbitrator has not been able to complete the award within the stipulated time, then the parties can approach the court for extension of time. Section 34 is setting aside of an award, and the award has to be executed under Section 36. Then we have 37, which provides for appeals, and 39.2 is delivery of the award. If the arbitrator does not deliver the award to the parties, then the parties can approach the court for delivery of the award. Now, Chapter 8 talks about finality and enforcement of the arbitral award. Now, the effectiveness of the arbitration is primarily dependent on the enforcement of arbitral award. Just now, we talked about the fundamental principles, fundamental principle of autonomy of the parties. Now, another fundamental principle of Arbitration and Conciliation Act is finality. Honorable Supreme Court in a recent case held that finality is a fundamental principle enshrined in the Arbitration and Conciliation Act. So today's session would mainly be concentrated about Section 35 and 36. Now, Section 35 says, subject to this part, an award shall be final and binding on the parties and persons claiming under them respectively. And Section 36 talks about enforcement. I would like to go through this section. It says, where the time for making an application to set aside the arbitral award under Section 34 has expired, then subject to the provisions of subsection 2, which is about stay, such award shall be enforced in accordance with the provisions of Code of Civil Procedure in the same manner as if it were a decree of the court. Subsection 2, it says, subclause 2, where an application to set aside the arbitral award has been filed in the court under Section 34, the filing of such an application shall not by itself render that award unenforceable unless the court grants an order of stay of the operation of the said arbitral award in accordance with the provisions of subsection 3 on a separate application made for that purpose. Next, upon filing of an application under subsection 2, for stay of operation of the arbitral award, the court may, subject to such conditions as it may deem fit, grant stay of operation of such award for reasons to be recorded in writing. And it has a proviso which says that while considering the application for grant of stay in the case of an arbitral award for payment of money, the court will have due regard to the provisions for grant of stay of money decree under the provisions of Code of Civil Procedure. So this is what Section 36 provides. When can the execution petition be filed? Now the award has been passed. Now what is the time period after which an execution petition can be filed in the court? We've just gone through Section 36, according to which an award holder would have to wait for a period of 3 months after the receipt of the award prior to applying for enforcement and execution. And during this intervening period of 3 months, the award may be challenged in accordance with Section 34 of the Act. And if in challenge, the court finds the award to be enforceable, there can be no further challenge as to the validity of the arbitral award at the stage of execution. Now, this is very important, that once the challenge under Section 34 has been dismissed, there can be no further challenge. Now, what is the procedure for enforcement? The procedure for enforcement of the execution of arbitral awards is primarily governed by Part 1 of the Arbitration and Conciliation Act. Now, Section 36 says that the award has to be executed in the same manner as if it were a decree of the court. So, decree of the court is executed under the provisions of CPC. So, let's see what does the CPC say. For execution of decrees under the CPC, the decree holder is required to first approach the court which passed the decree. Under Section 38 of the CPC, a decree may be executed either by the court which passed it or by the court to which it is sent for execution. This is Section 38, and Section 39 talks about the transfer of the decrees. Section 39 says that on the application of the decree holder, the court which passed the decree shall send the decree for execution to the court where the judgment debtor resides or carries on business or works for gain or where the property is located. Now, under CPC, a transfer is required from the court that passed the decree to the court where it is to be executed. Now, what is the enforcement procedure under the Act? Under the ANC Act 1940, a decree was required to be passed by the civil court to make the award executable. At that point of time, whenever the award was passed, it had to be made the rule of the court, and an application used to be filed in the court, and a lengthy procedure as that of a civil suit used to be followed. The reply would be taken from the other parties and issues would be framed and evidence would be recorded. So it was more or less like a civil suit only. But under the 1996 Act, there is no such requirement of a decree to be passed, and the award itself is executable as a decree. So, Honorable Supreme Court in Sundaram Finance held that an award under Section 36 of the Act is equivalent to a decree of the court only for the purposes of execution. Made it very clear that it's not a decree. It's like a decree. It's akin to a decree. So Section 38 and Section 39 of the CPC are not applicable because unlike Section 38, in case of an award, there is no court that passes the decree. So therefore, there is no requirement to seek a transfer of the decree in terms of Section 39 of the CPC to the executing court. And this is very clear from Sundaram Finance. An arbitral award can now be executed by directly filing the same in any court that is capable of executing the decree. Now the question is, what is the appropriate forum, which would enforce the arbitral award? Section 36 does not refer to any court. It merely says that an award shall be enforced in accordance with the provisions of CPC in the same manner as if it were a decree of the court. Now, at this point of time, it would be relevant to refer to the definition of the court, which says, in domestic arbitration, the principal civil court of original jurisdiction in a district would, in exercise of its original civil jurisdiction, would have the jurisdiction to decide the questions forming the subject matter of the arbitration. Section 42 talks about specifically talks about jurisdiction. It would be relevant to go through this section too. It says, notwithstanding anything contained elsewhere in this part or in any other law for the time being in force, where with respect to an arbitration agreement, any application under this part has been made in a court, and that court alone shall have jurisdiction over the arbitral proceedings and all subsequent applications arising out of that agreement, and the arbitral proceedings shall be made in that court and no other court. And the court referred here is the court having jurisdiction. It does not mean the court having no jurisdiction. It means the first application, if it is made to the court having jurisdiction, then all subsequent applications would be made to that court. Now, till recently, there was a lot of confusion about the jurisdiction of the executing courts, and different high courts had taken different viewpoints. Himachal Pradesh High Court and Honorable Madhya Pradesh High Court had held that the execution proceedings need to be first filed at the court that would have jurisdiction over the arbitral proceedings. And that conclusion was on the basis of Section 42 of the Act, which deals with the jurisdiction over arbitral proceedings, and read with Section 21E of the Act, which defines a court. Now, reading these provisions in the light of 36 of the Act, which provides for an award to be enforced in the same manner as if it were a decree of the court, the courts concluded that an arbitral award must be executed by obtaining a transfer of the decree as per the procedure laid down in Section 39 of the CPC. Honorable Punjab and Haryana High Court had a different opinion. In IndusInd Bank versus Fuller Transport Company, Honorable Punjab and Haryana High Court held that an award can straightaway be filed for execution before the court where the assets are located. Now, this was way back in 2012. After that, Abdul Samad came recently. But in 2012, Honorable Punjab and Haryana High Court said that Section 42 of the Act does not extend to execution of the arbitral award. That means Section 42 does not prescribe the jurisdiction of the court if the award has to be executed. It also said that Section 36 of the Act aims to create a legal fiction. It merely creates a legal fiction without implying that the award is a decree of the court. So this authority of Honorable Punjab and Haryana High Court made it very, very clear that award is not a decree. A fiction of decree is created just because we have to execute it. Then came Sundaram Finance versus Abdul Samad, 2018. An Honorable Supreme Court approved the view taken by Honorable Punjab and Haryana High Court. It was held that no decree is passed in case of an arbitral award, and the award is executed as a decree by fiction. And the bench also observed that an award under Section 36 of the Act is equated to a decree of the court for the purposes of execution, and only for that purpose, for the purposes of execution and nothing else. It was further observed that there was no deeming fiction anywhere to hold that the court within whose jurisdiction the arbitral award was passed should be taken to be the court which passed the decree. And it was further held that petition for enforcement of an award may be filed in any jurisdiction of the country where such a decree is capable of being executed. And there is no requirement of obtaining a transfer of the decree from the court which has jurisdiction over the arbitral proceedings. Now the question is, what is the scope of inquiry by the executing court? When a petition is filed for execution, what are we supposed to do? The grounds of challenge are exhaustive. They've been mentioned in Section 34. And now the executing court cannot expand the grounds for refusal of the enforcement. It cannot examine the merits of the case as is done in appeal. It's not an appeal on merits against the order of tribunal. Once an award is found to be enforceable by a court, it would be enforced like a decree of the court. In this authority, ARSS infrastructure projects, it was held that the court has no jurisdiction to modify the award, and the jurisdiction of the court is limited only to ensure that the award is implemented. That is when a petition is filed and we are sure that it has become enforceable after the challenge of Section 34 is over. The only thing that we are supposed to do is to enforce the award. So it's very clear from these authorities that the executing court has extremely limited jurisdiction. It has to do two things. First, it has to make inquiry as to enforceability of the award. And second is that after that, the only option left with the court is to enforce it, unless the enforcement has been stayed. Objections of the award debtor. Many a times we had seen that as soon as the execution petition is filed, the judgment debtor appears, and the first thing that he does is he files objections. So, okay, the question is, can the objections of the AD be taken in the execution petition? Now we have this authority of Honorable Punjab and Haryana High Court, Mahinder Singh and others versus Gurdarshan Singh. It was held. In this case, the facts are that the award debtor filed objections and also filed an application for dismissal of the execution petition, and it was dismissed by the executing court. The petitioner did not challenge the arbitration award by filing petitions under Section 34. And consequently, the arbitral award became executable as a decree. Honorable High Court held that objections raised by the petitioners could not be entertained by the executing court. Any such objection should have been raised only by way of petition under Section 34 of the Act. And once that stage is over, then objections cannot be entertained by the executing court. Similarly, Honorable Supreme Court in Punjab State's Civil Supplies Corporation Limited and Nather versus Messrs. Atwar Rice and General Mills. In this case also, an award was passed and the respondent filed an application under Section 34. This application was dismissed, and after that, execution petition was filed, and in the execution, the respondent raised certain objections under Section 47 of the CPC. Executing court upheld the objections raised by the respondent and dismissed the execution petition. Honorable Supreme Court said that all the objections under Section 47 CPC ought to have been raised by the respondent under Section 34 of the Act. None of them could be allowed to be raised in execution once the award became final and attained finality as a decree of the court. Now let's talk about the stay of the award. Like, what is the situation about the stay? Prior to Arbitration and Conciliation Amendment Act 2015, an application for setting aside an award would amount to a stay on the proceedings for execution of the award. And prior to amendment, there were many authorities which also held that a moment an application under Section 34 is filed, that automatically stays the execution. Now, the amendments were done in 2015. Section 36 of the Act was amended and it did away with the automatic stay provisions. Section 26 provided, it said that nothing contained in this Act shall apply to arbitral proceedings commenced in accordance with the provisions of Section 21 of the Principal Act before the commencement of this Act, unless the parties otherwise agree. But this Act shall apply in relation to arbitral proceedings commenced on or after the commencement of this Act, that is 23rd of October 2018. Now, after the amendments, BCCI versus Kochi Cricket, this authority came of Honorable Supreme Court. And in this authority, Honorable Supreme Court bifurcated the proceedings. that is the proceedings before the before the arbitrator, and the proceedings in the court. Honorable Supreme Court says that in respect of the proceedings before the arbitrator, the amendments would apply prospectively, but in respect of the proceedings in the court, the amendments would apply retrospective. And it was held that right to obtain an automatic stay under Section 36 was not a vested right. Therefore, there would be no automatic stay of award unless a separate application was successfully made for such a stay. So now the position is, okay, after that, again, then in 2019, certain amendments were done to the ANC Act, and this 2019 amendment deleted Section 26 without removing the basis of BCCI versus Kochi, and introduced a new Section 87, which again provided that the amendments would apply prospectively. And the effect of this provision was that this brought the provision of automatic stay back. Now then came Hindustan Construction Company Limited versus Union of India, in which Section 87 was challenged being unconstitutional. In this case, again, Honorable Supreme Court did away with automatic stays. The facts were that there was a contract between an infrastructure company and a government, and award was given in favor of the infrastructure company, and the government had to pay an amount of rupees 6,000 crores. But because of the automatic stay, now this amount was stayed. Now this infrastructure company, while it was completing the project, it had taken, had kind of taken money from certain creditors, and it had to pay the money back. And because this amount was stuck, because of the automatic stay, the company was not able to pay the amount to the creditors. Now, those creditors started insolvency proceedings against the company. Now, the contention of the company is that despite having 6,000 crores as recoverables, there was a danger of the company being declared as insolvent because it was not able to pay the amount. So, in these circumstances, Honorable Supreme Court struck down Section 87 as unconstitutional and revived Section 26 of the 2015 Act. And the situation now is that again there is a bifurcation, that in case of proceedings before the arbitrator, the amendments would apply with prospective effect, and in case of the proceedings in the court, they would apply with retrospective effect. Now the question is, now we know it is clear that there is no automatic stay, and the party will have to move an application if the party wants a stay, and the court, after considering the entire facts and circumstances of the case, might grant stay. Now the question is whether the stay should be conditional or unconditional. Section 36(3) says that the court may, subject to such conditions as it may deem fit, grant stay. That is, conditions can be imposed by the court for reasons to be recorded in writing. And proviso, there is a proviso which says that the court will have due regard to the provisions of grant of stay of a money decree under the CPC while considering the application for grant of stay in case of an arbitral award for payment of money. And the relevant provision under the CPC is Order 41, Rule 1 and 5, which deal with appeals from money decrees and stay on execution of a money decree. In Sihor Nagarpalika, it was made clear by Honorable Supreme Court that power to order stay is discretionary. It is the discretion of the court when an application comes. It is completely the discretion of the court whether to grant stay or not. It was held that discretion lies with the appellate court to direct either deposit of the amount disputed in the appeal or to permit such security in respect thereof being furnished as the appellate court might think fit. And it was also laid down that ordinarily execution of a money decree was not stayed inasmuch as the satisfaction of a money decree does not amount to irreparable injury, and in the event of appeal being allowed, the remedy of restitution was also available. So this authority is applicable to the execution of the awards, because in award, more often than not, most of the time, it is the money decree. Now, what are the conditions for stay? Under Order 41, Rule 5, it says, mere filing of an appeal will not operate as a stay. This is clear in the Arbitration Act also. And it says when the appellate court has to consider the application regarding stay, it will consider whether substantial loss will cause to the party, or the security has been given by the applicant for due performance. These are the considerations which have to be taken into account by the appellate court. So unconditional stay on the execution of a money decree is not contemplated even in CPC. The only discretion available to an appellate court while deciding an application for stay of a money decree is to either direct deposit of the amount disputed in the appeal, or to permit such security to be furnished. An unconditional stay is not contemplated and has been clearly ruled out by judicial precedent. Now the question is, how much should be the quantum? It is correct that a stay can be given, conditions can be imposed. In case of a money decree, the other party can be asked to deposit the amount, but how much should be the quantum of the security deposit? Should it be the entire amount, or it depends on the discretion of the court? Now we've just gone through the authority and the provisions that the court has complete discretion in the grant of the stay. So we can also say that if the court has the discretion to grant stay, the quantum of the security deposit should also should follow such a discretion, because the ANC Act does not stipulate any fixed percentage. It does not say how much should be the security, whether it should be the 100% security or 50% security. It just doesn't say anything. This is an authority in which Honorable Supreme Court directed stay of award subject to the JD depositing the entire amount. And the Calcutta High Court, Honorable Calcutta High Court had directed deposit of 100% of the amount. So Honorable Supreme Court just modified the order to the extent that it was the petitioner was asked to deposit 60% of the awarded amount and 40% of the by way of a bank guarantee. These are another authorities in which in Kanpur, Jal Sansthan, Supreme Court again asked the party, the judgment debtor, to furnish the security of the entire amount. Similarly, in Power Make Projects, 100% award amount was ordered to be deposited for grant of stay. Now the question is, what is the extent to which provisions of CPC will apply in execution? Because we've just gone through where it says that due regard has to be had to the provisions of the CPC regarding money decree. Now, in this case, PAM Developments Private Limited, this is a recent judgment of Honorable Supreme Court. State of Bengal, West Bengal was granted unconditional stay on an award by the Calcutta High Court on account of Order 27, Rule 8A of the CPC, which exempts the government from the requirement to furnish security. Now, Honorable Supreme Court says that the phrase is have due regard to. In the proviso to Section 36(3), the phrase is have due regard to the provisions. That would mean that you will take into consideration the provisions of the CPC, but they are only directory and not mandatory. You are not bound by the provision. And Honorable Supreme Court also said that no special treatment has to be given to the government while considering application for stay of the award. So that means in case of the government also, the government will have to deposit most of the 100% of the amount or whatever amount that is ordered by the court. Can there be a situation where operation of the award be stayed without any conditions, without imposing any conditions? There could be situations where when you're dealing with the execution and you're hearing arguments on the application for stay and you come across that the award is perverse or is prima facie hit by one of the grounds of challenge in a section 32, it appears perverse on the face of it. And in these circumstances, you would not want the party to deposit 100% of the award amount, and you can stay the execution without subjecting the award debtor to any conditions. Next is interim award. Can the arbitrator pass an interim award, and is it enforceable like the final award? So the provision is, it is contained in section 31. It permits the passing of an interim award by the arbitral tribunal under section 31(6) of the Act on any matter with respect to which it may make a final award. And an interim award is different from an interim order in as much as an interim award is a final award but made at an interim stage. This is a case of Honorable Delhi High Court where interim award is passed in case of admitted liability. Most of the time, interim awards are passed where the other party admits the liability, in respect of the part of the claim. Honorable Delhi High Court said that passing of an interim award ensures that the party to whom an amount is admittedly payable does not have to wait determination of the other disputes to be finally resolved. It means the moment an interim award is passed in case of an admitted liability, the party in whose favor the award is passed can file for execution, and if the other parties agreed, if at all, because if it's not on admitted liability, there's some other matter regarding which interim award has been passed, then that party can file objections under section 34. It is very much within the powers of the arbitral tribunal to pass an interim award on the basis of clear and unambiguous admissions by a party under section 31(6) of the Act. And the definitions provide, it says that the term arbitral award would include an interim award also. So in view of the same, an interim award, unlike an interim order under section 17 of the Act, can be challenged under section 34 of the Act and not under section 37 of the Act. Now this is an authority of Honorable Supreme Court where the issue was whether the decision of the arbitrator on the issue of limitation is an interim award. So Honorable Supreme Court says that if issue of limitation was disposed of finally, such award would be an interim award within the meaning of section 21(c) of the Act, and it would come within the expression arbitral award and could be challenged under section 34 of the Act. Now, the question is, what is the limitation period for enforcement of the award? Suppose an award has been passed and section 36(3) says that when the time for making an application under section 34 has expired, that is 3 months have expired and the application can be moved to the court. Suppose the application is not moved within a period of 3 months. Then what is the limitation period within which the party can come to the court for enforcement of the award? So this is, the authority is Mr. Umesh Goel versus Himachal Pradesh Cooperative Group Housing Society, 2016. It said that awards are deemed as decrees for the purposes of enforcement, and the limitation period for enforcement of such an award is 12 years. So this is what I have for today's session. Thank you very much. Thank you.
Thank you, ma'am. So now I can request the members to ask the questions. Ma'am, just want to check one more thing with you. This PPT that you have shared today, would this be available on the Academy website?
Yeah, I don't know about the website, but anyone who wants it can take it from the the academy.
On the Academy,
They
okay.
can make a call to the academy and they'll send the PPT. In fact, I'll send the PPT because the academy in turn tells me to send the PPTs.
Okay.
So I'll do that. Yeah.
So yeah, I think Academy can have a you can members can call up the Academy and then
Yeah.
probably you can send out an email to one email to everyone if anyone wants it, because I think a lot of members who've been attending this session would definitely want to have the access to the
Yeah,
authorities that
that's
you have
not a
shared.
problem.
Yes, ma'am.
Yeah, yeah. I'll send the presentation.
Yes. And also, in case members do not want to go through that channel, this video would be uploaded on YouTube, and you
Of course.
can you can ask for the link from the academy, and you can rerun this training. You can rerun this
Yes.
webinar on YouTube. That is also one of the possibility that we can also think
Otherwise,
of.
anyone can give me a call and I'll send the PPT. It's absolutely no problem.
I'm sure, ma'am. I think no, I don't have no doubts about it, and I'm sure everyone who knows you would not have any doubt about it. Just now getting into the question part, we have a question, ma'am. It's more of a clarifying question. The question is, which court will have jurisdiction to entertain execution petition if the court of lowest grade is competent?
See, when I said that the court are competent to have jurisdiction, we also discussed about the definition as mentioned in section 2(1)(e) of the Act, and it says that the court, a principal court of original jurisdiction in the district, which is the court of district judge, and it includes the court of additional district judge. So the application for execution would be would lie only in the court of ADJ or in a principal civil court of original jurisdiction.
Okay, ma'am. I'm sure that answers the question of the member. I think yes, I got a thumbs up on that. So I think the person has got the answer. I think apparently we don't have much questions. There were a lot of I think regards members have sent in saying thank you for your time and wonderful presentation. So those things people have there are a lot of I think appreciation has been done. But I think the
Thank
questions
you
are
so much.
I think the questions
Nobody has
are
asked any questions.
the questions are few. I think this is the one question that I had and I shared with you. But I'm probably that's the reason, because I think everything was dealt in a way that things were made clear and authorities have been. You already listed a lot of authorities in your session, ma'am. So I think people can either come back and ask the question. But for now, I think we are all on the same page. So what we had, what I think, ma'am, what you were aiming to achieve, I think that has been achieved. So the transfer of knowledge has been done completely, and that's why members do not have any doubts or any question about it. But I'm sure, I think, I being a trainer myself, I understand that sometimes, when you say that there are no questions, the questions sometimes roll, come later on. So that I think that is something that you can expect.
Yeah, it's perfect because I today ended the session slightly before. One is supposed to go on at least for 45 minutes, but I ended the session in 40 minutes because this is.
I think because it's also that you've been now taking sessions, ma'am, and everyone we've been doing these sessions on a weekly basis. So we understand
Yeah,
that how important it is to to have the session in a specific time and open the forum for questions. So
yeah.
I think while talking, I have another question. The question I'll just put it before you, ma'am. It says, if an award is passed in Chennai and its execution is sought in Hisar, Haryana, the JD says he did not get any notice of arbitration proceedings. Whether he shall have the approach the arbitrator, whether he should approach the arbitrator or can challenge the award under Section 34.
Uh, See, we have discussed. Now, this is a very unfortunate situation, and we are having these kind of cases, a lot of these kind of cases in the district courts, where the financial institutions, they kind of give loans to they give small loans, and there is the stereotyped agreement that they have where the other party is supposed to put signatures on the dotted lines, and the other party, normally, the poor and gullible people are over there, and they don't even know that some kind of arbitration clause is there. But this is no excuse because that party puts signature. So what these financial institutions are there doing, suppose the party is in Hisar, the judgment debtor is in Hisar, though he makes an application for loan at Hisar. The loan is advanced to him at Hisar. Judgment debtor resides at Hisar. He works for gain at Hisar, but the arbitration is conducted at Chennai. Yeah, and of course, the financial company turns around and says that we had issued the notice to the judgment debtor, and the judgment debtor did not appear, and because of that, you know, um, he was proceeded ex parte, and it's an ex parte award. But you know, see, technically, uh, that period of 90 days, within that 90 days, the judgment debtor can file objections, under Section 34. And once that time period is over, then the award becomes executable under Section 36. And for this purpose, the financial institutions are duping the poor people, and they purposely have arbitration proceedings at Chennai, whereas there is no ground to have. Why would they have the arbitration proceedings at Chennai, where everything is happened in Haryana at Hisar?
Yes.
They should not be doing it, but it is happening a lot. It is happening all over India. These kind of things are happening, and the executing courts, they do not know what to do in these kind of situations, because Section 36 is very strict. Section 36 says that when the time is over, the time of 3 months to challenge the award is over, after that the award becomes enforceable, and the executing court does not have any jurisdiction but to enforce it. So they don't know what to do, and there is no authority also on the point. So my point is that there should be if the executing court feels that there are so many points which I can say which go against this kind of an arbitration, because it's not an arbitration, it's a kind of fraudulent kind of a thing. It's a sham arbitration, right? See, the Arbitration Act, it says that party autonomy is very important. Honorable Supreme Court has also held that party autonomy is one of the most important fundamental principles of Arbitration and Conciliation Act. Party autonomy means that everything has to be decided by the parties with mutual consent. There has to be an ad idem between the parties to go to the arbitration. But in these kind of cases where the loan is advanced by the financial institutions, the other party is completely missing from the scene. The other party has never had the intention to go to the arbitrator. The party did not even know that there was an arbitration clause in that agreement. So
Yes.
that mutuality is completely missing, which is very basic for the Arbitration and Conciliation Act.
Yes. Yes.
Then Arbitration Act talks about equality of the parties. Section 18 talks about that both the parties have to be treated equally. Now, this again is missing in this kind of an arbitration. And the any proceedings, see, it's not that if arbitration is taking outside the court, the fair play would be missing from it, and the party would conduct the proceeding in any which way. Fair play has to be there, transparency has to be there, the proceedings have to be conducted honestly and nicely, keeping in view the interest of both the parties. But what is happening in these kind of things are that the entire proceedings are conducted behind the back purposely with a dishonest intention, because the financial institution knows it very well that if the arbitration is conducted locally where the judgment debtor is residing, otherwise what is the harm in conducting arbitration at a local level where you've done everything, you've advanced the loan, your cause of action has arisen at Hisar and everything has. Why are you holding the arbitration at Chennai where the poor person cannot afford to go on each and every hearing? So they are doing it with a dishonest intention, because they know that if everything is done locally, then the judgment debtor would have he would have legal assistance. He would appear in the arbitration proceedings with the lawyer. He would be able in a better position. He would be able to defend himself nicely. He would be able to conduct the proceedings nicely, and then eventually, when the award is passed against him, he would be able to challenge the award within time, within a period of 3 months. And this is what the financial institutions do not want. They just want that this period of 3 months should pass, and so that the award becomes enforceable, and after that, judgment debtor is left without any remedy. So my point is that when we know that financial institutions are doing it with dishonest intentions, and they are kind of duping the poor and gullible people, as of now there is no authority. But my point is that Section 36 gives us a mandate to execute an award which has been obtained following due procedure under the Arbitration and Conciliation Act. And I have just highlighted how these financial institutions are, violating the provisions of Arbitration and Conciliation Act with impunity. They are just not bothered about the provisions, and it is the arbitration that is being conducted by the arbitration is in fact a sham arbitration. It is not in fact a legal and a valid arbitration. So a sham arbitration would only produce a sham award. So I'm just making a point. Since there is no authority on the point, my point is that mandate is to enforce a legal and a valid award, not a sham award. When we know that the financial institution has been dishonest from the word go, so something should be done. Something should be there. And if the district courts, go on executing the awards like this, of course, there would not be any authority from the higher courts, because I know I have talked to many additional session judges, and they have this pain that we do not know, what to do about these kind of awards where the award has been passed in Chennai and the judgment debtor, is residing here. He never went to attend the arbitration proceedings. So in this kind of a situation, I would suggest that, this is just my thought, my personal opinion, that the once or twice, if we refuse to execute this kind of an award, and then the financial institution would obviously go to the higher court, and we will have some authority on the point, right? If we go on executing the award, this law on this will not evolve. There will not be any development. So something has to be done about this. This is a kind of scam which is happening, and they are taking advantage of Arbitration and Conciliation Act.
Yeah. I think it actually opens up a different world of thoughts and discussion. What this question has led us to, but I'm sure I think you.
Oh yes. Talking about the authority. Sorry, I'm interrupting you. I just remembered there is an authority of Honorable Supreme Court lately. I think it has come in the year 2020. Perkins something, and it says Honorable Supreme Court has made it very clear that a person who has interest in the outcome of the dispute cannot have the authority to appoint the sole arbitrator. And in these kind of litigations, it is the financial institution who is appointing the arbitrators, you know. The other party is absolutely, they do not have any say. So this is another point against these kind of awards.
What was the party name you mentioned?
It's Perkins. I'm forgetting. It's Perkins something.
Perkins?
Lately, it has just come. Perkins something. If you, I'll try to look for it.
I'm searching, ma'am. I'm searching it for right now. I'm searching it right now. I think give me a minute. I will also be able to give you the citation.
Yeah. Just write that a person having interest in the outcome of the dispute cannot appoint the sole arbitrator. Then this authority would come.
Ma'am, you were just giving it party name. I think party name would be much faster and easier if you have something. Perkins, you're saying? Should I go?
Perkins, Perkins. Honorable, if I'm not wrong, because I'm forgetting.
Perkins, Eastman Architects, DPC versus HSCC. Is that
which year is it?
It's 2019.
Yeah, it could be the same. And what does it say?
I'm just opening up the judgment now. Just give me a second. It's an Honorable Supreme Court judgment, and it's about appoint a sole arbitrator in accordance with Clause 24 of the contract dated 22nd of May, executed between the parties. It's talking about Ministry of Health and Family Welfare. The respondent was disfurious of comprehensive.
I do not have the mobile also. Otherwise, I would have taken on that.
No worries, ma'am. I think I will. I think this is before Justice Uday Umesh Lalit and Indu Malhotra, ma'am.
Okay. Can you put my PPT once? Can I open my PPT right now?
Ma'am, you can open it. I will just make it visible to everyone.
Okay, let me just see if I.
Sure. You can just open your PPT on your computer, ma'am. It will be visible to everyone. I think that's the third icon.
This is the authority. This is the one. Perkins Eastman Architects.
Yes, ma'am. That's the yeah. That's the same one I'm talking about.
Yeah. So this is the authority.
I have the citation as well. What I'll do is I'll just put the citation in the chat box. And it's 2019 SCC Online SC 1517. I'll just put the citation. And you already mentioned the party name, so I can also put the party name in the chat, so members can see that as well. Putting that, and I'll just put the party name as well. So I put in the party name and the citation, ma'am, for this. So I think now the detailing part that you were trying to do on this.
It's a very good authority, because this is what the financial institutions are, doing. They are solely appointing the arbitrators, and they are interested in the outcome of the dispute, and they are not taking the other party into confidence, whereas it's both the parties who have to decide everything. In case of an arbitration, it is both the parties who have to decide about the arbitrator, it is both the parties who have to decide about the law to be applied, it's the parties who have to decide the procedure, it is the parties who have to decide the place of arbitration. But these financial institutions are conducting the arbitration proceedings in completely illegal manner. And they're taking the courts for a royal ride. And I don't think that we should give effect to these kind of awards when we know that, their intention is dishonest from the very beginning.
One of the members has also mentioned the same authority like you were mentioning. So that is over there. Ma'am, I think now we have a couple of questions. So I think I'll just move to the next question. It's a scenario. Scenario is in case the award having become decree, an appeal set aside by the Honorable High Court only on the grounds of limitation point, not distributed the remaining whole award. On the case law laid down by the Honorable Supreme Court, the decree passed by the lower court as per the old act. In that case, the court could not touch the findings already given. Is that a decree? Is that decree legal?
I did not get the question.
It
What
is.
is he trying to say? That there is an award passed and that
There's an
award is set aside by Honorable High Court.
Honorable High Court, and then we move to the Honorable High Court on the point of limitation point, and it is not distributed. It has not distributed the whole award.
See, if it's dismissed on the point of limitation, how can you say that the rest of the award is valid?
I think I can just
something is
ask.
Missing in the question.
I can ask the member. The name is not mentioned over here. It just says anonymous. So if the member can put in the question precisely what exactly is need to be asked, so we can probably answer that. I'll come to the next question. It's talking about Section 34. Whether court, while deciding objection under Section 34, can take technical assistance in the cases involving engineering and etc.
Yeah, of course. Technical assistance can always be taken. There is no harm in taking any kind of assistance. If the court requires technical assistance, it can be taken.
Certainly. Thank you for a short and crisp answer. Now, a question is from Rajni Kaushal ma'am, from who's CJM at Kethel. I think this is a scenario, so I'm going to read it out. Sometimes party in an agreement to sell mention that any dispute caused the same shall be subject to arbitration. Later, there was some dispute between the parties, and some person known to the parties wrote the settlement in the form of arbitral award. What is the validity of the same, and whether the award is enforceable like a decree for a specific performance?
See, the entire procedure has been specifically mentioned in the Arbitration Act, starting from the arbitration agreement, what are the requirements of an arbitration agreement, and how the parties have to go about in the arbitration. So it is not clear in the question what kind of proceedings are conducted, whether it was both the parties who decided to have, whether it's
it's been said that only one party decided picked up an arbitrator, and then they settled the arbitrate or the entire arbitration.
No. See, this could be a compromise, but certainly not arbitral award, which is equivalent to a decree. If something is happening, see, here arbitration is as good as the proceedings of the court only. It's just that it is happening outside the court. But it has to be done by following a proper procedure as laid down in the Act. It cannot be done in a casual manner. It is a highly professional thing to do, and there are so many rules and regulations which have to be followed by the parties and by the arbitrator. So this kind of a thing where there is an agreement to sell is there, and there could be a clause, but if one of the parties entrusts the settlement thing to one particular person, and that first person tries to bring about a compromise, this could be a written compromise between the parties, but this is certainly not an award. It's certainly not an arbitral award, which could be executed under Section 36.
Okay. I think this is what I think Ma'am Ranjana asked is more of like when you have two families doing some dealing, and then someone who's elder in the family or the common family, they jump in. It's more of like we have panchayat.
Panchayats, yes.
I think it's more something on those lines.
See, panchayats were in olden times, they were doing the job as the arbitrators are doing, but now it has to be done in a more professional manner, following certain rules and regulations that have been prescribed in the Arbitration Act. So the elder of the family steps in. It's a very informal way of settling the dispute. So it's not an arbitral award.
So the following question to this is, ma'am, does it mean that in case of standard form contracts, even the clause providing the arbitration has to be read down, and civil court should have the jurisdiction to try it?
No. See, clause is always valid. Even in agreement to sell, where that clause provides that in case of a dispute, the parties would refer the matter to the arbitration. There's nothing wrong with the clause, but both the parties have to agree on there is a procedure prescribed for appointment of the arbitrator. The procedure is there for submission of the claims of both the parties. how the arbitration proceedings have to be conducted and in how much time the proceedings have to be concluded. And if the arbitration proceedings are not concluded within a period of 1 year from the completion of the pleadings, then it could be extended the time. So there's a detailed procedure which has been provided. There's nothing wrong with a standardized form of contracts providing a arbitration clause. That can be done, and this kind of clause is completely valid. It is there in Section 7 of the Act, which provides that this is valid. But at the same time, the proper procedure as mentioned in the Act has to be followed. You know, the arbitrator
procedure.
has to,
Yeah.
yeah.
Ma'am, perfect. I think that brings us to the end of questions as well. So I think it was, we were thinking that there are no questions, but I think members were, they needed some time to come up with the questions. So, and we had a lot of questions, and I think I will end this session with this one, compliment that has been given by, name is not mentioned here. It says the presentation of great significance, clarifying all the dilemmas.
Thank you so much. Thank you very much.
that is
Whoever
our
has given the compliment, thank you, sir. Thank you, ma'am. It really means.
Yeah, and so I wanted to share this because this actually, the questions is one. I think the feedback like this, the motivation messages like this also, I think, motivates everyone. Not only the speaker, but also everyone who's listening these webinars. So, ma'am, thank you so much. Thank you so much for
Thank you, everyone. Thank you.
Taking out time. And if you just allow me, I'll just give a vote of thanks on behalf of Academy and on your behalf.
Yeah.
So thank you, everyone. Thank you, all members who joined in from across Punjab, Haryana, State Judiciary. Thanks to the system officers who've been working and ensuring that everyone can connect. And thank you to Chandigarh Judicial Academy for making the efforts and coming up with the new topics. Thanks to the main thanks goes to today's speaker, Mrs. Ranjana Aggarwal, ma'am, because had she not been there, the session would have not been possible. So thanks to you, ma'am. On behalf of the Chandigarh Judicial Academy and on behalf of SSC Online, I, Chetan Singh Gill, sign off from this webinar with the promise that we will see you next week with a new webinar.
Thank you. Thank you.
Thank you. Take care.